Christian Louboutin and Yves Saint Laurent have been battling over the color red for many months now, but in September, a federal court of appeals in New York rendered a decision in this case. And who won? Well, it depends on who you ask because both sides are claiming major victories. I'm Spencer Mazyck, and joining me now is the attorney for Christian Louboutin, Harley Lewin. He is a partner at McCarter English. Harley, thank you for joining us today. So, Harley, before we get to the Second Circuit decision, can you tell us what happened in this case? Just very briefly, I understand that your client initiated the action.
It did. Well, Christian Louboutin has been producing shoes with red soles for 20 years. And in 2011, the beginning of 2011, we discovered some shoes showing up in the UK, France, and the US, put out by YSL, and they carried red-soled shoes. And there were some negotiations. Those negotiations broke down, and Mr. Louboutin made a determination, along with his management team, to file a lawsuit.
Yes, but has Yves Saint Laurent been producing this monochromatic red shoe since the 1970s?
They claim to be. We've not been aware of it. And they've indicated in some of the court proceedings that they had earlier shoes. That may be. We're not talking about whether the shoes were made. We're talking about whether they were ever sold to the public. And we've seen no indication of that.
Okay, and when did Louboutin trademark his now iconic red-soled shoes?
About 2007, 2008, about after 20 years of use.
Okay, and what ultimately did the Second Circuit decide here? How did it rule in this case?
Well, the Second Circuit came down with a Solomon-like decision. They gave us what we wanted for the most part, which was a finding that Mr. Louboutin's red sole was indeed famous, was entitled to protection, and was enforceable. But, they said, that was only where the outsole contrasted with the rest of the shoe.
So which means what exactly?
Well, essentially, if the shoe is all one color, what is called in the footwear industry monochrome, right? Say it has a red outsole. The argument is that if it has also red uppers and red heels and red straps, and all those reds are the same color, the outsole disappears and it isn't seen separately. That's the carve-out that the Second Circuit did. They said under those circumstances, Mr. Louboutin's trademark did not extend to that.
Which means that Yves Saint Laurent gets to continue producing this monochrome red shoe.
Assuming it meets those standards, it would, yes.
Well, and so if they can continue doing that, then how is this a win or a victory for your client, Christian Louboutin? Well,
the lower court held, in a preliminary injunction hearing, adopted a per se rule. And it felt that, notwithstanding all of our proof, which it agreed with, that in the fashion industry, a single color cannot serve as a trademark. That was a game changer for Louboutin, because the court went on to invite the other side, YSL, to submit a summary judgment motion. And the court basically said, if that motion came in, it would hold Mr. Louboutin's trademark invalid. That's why we took the appeal right at that point.
Well, though, but has your client's trademark been narrowed? I mean, is the company better today than before it filed the lawsuit?
Well, I think so. Overall, yes. I would say yes. We think that, let me back up. The decision in the Second Circuit was kind of nifty, because the carve-out was premised on it not having sufficient evidence to extend the trademark that far. That leaves us open to live another day.
Okay. So you may try the same case sometime later in the future.
I would caution any third parties believing that they can sort of get away with knocking off Mr. Louboutin's shoes to think twice.
Okay. But right now, though, there is sort of a limited trademark, which wasn't the case before the action was filed.
Correct.
And so what's left in this case? I think that there are some counterclaims by Yves Saint Laurent.
Correct.
What are they exactly?
Well, we don't think that much of them. There's one claim for fraud on the patent office, which is sort of traditionally raised as a counterclaim or defense. You threaten to claim that somehow or other you obtained the trademark under false pretenses, which just isn't so in this case. And frankly, offhand, I don't remember the other one, but it's of similar nature. We simply don't give them much strength at this point.
So you think they're going to settle out of court, maybe?
I think there's good reason both sides to settle out of court at this time. I mean, the appellate court took several unusual steps, and one was to direct entry of a judgment from the appellate bench. It only remanded the case insofar as the two remaining counterclaims. So from the point of view of Louboutin, the case is over. right? We have to theoretically defend those counterclaims.
Right, of course.
But YSL has no good reason, we don't think. Now, we remain to talk to each other, though. We're engaged in talking to our clients now to take instructions, and the next step would be to talk to each other.
And so how significant is this case for the fashion industry?
Huge.
How so?
Well, as I said, it was a game changer. And the adoption of a per se rule by the lower court, where the lower court indicated that in its view, notwithstanding everything that we did, that a single color cannot serve as a trademark in the fashion industry, pretty much put the worldwide fashion industry into apoplexy. Everybody held their breath. Everybody wanted us to appeal the case.
Well, yes, because I think other brands use color, like Tiffany's little blue box, Cartier's red packaging. I mean,
sure.
A lot of brands use color.
Hermes orange,
right, exactly.
UPS brown. The court distinguished between what it called industrial use and fashion.
Okay.
And we didn't think much of that distinction, and neither did the appellate court. The appellate court essentially, that was the game changer, because that took what should have been a dispute surrounding whether or not there was infringement, and it then turned it into whether or not Mr. Louboutin had a trademark at all. And that's why we are very, very pleased.
It was imperative for you to win.
That's right.
Absolutely.
And that's why we're very pleased with the result.
How did you come to represent the French shoemaker, I should ask you?
Well, I represent a good friend of his, a woman by the name of Diane von Furstenberg, and I represented her for over a decade. And I received a phone call from her one day that a good friend of hers, who had a footwear company, was suffering from counterfeiting. And I do a lot of work in that area. I have done a lot of work in that area for DVF, and she said, you need to talk to this guy.
Oh, well.
So I met with him and his number one, Alexis Moreau, in New York a number of years ago, and that's where it started.
And do you have any advice for any other folks who are looking to represent high-profile fashion designers?
Yeah, actually I do. If you're on the younger side, and I get approached with this a lot from younger lawyers because they think it's all kinds of dramatic when you represent celebrities, and there is some of that, but first, learn what you do, do it well. Learn your craft. Remember that law is part science and part art.
Right, because nobody's going to recommend you if you don't know what you're doing.
If you don't know what you're doing, I don't care how handsome you are, how many parties you go out to, how fancy your brochure is or anything. That just doesn't matter. It doesn't matter if you don't do great work. And the reason that one person will recommend you to another is because they're safe, they're comfortable making that recommendation because of that quality level. And the second part is you service them. You particularly when you're dealing with high-profile individuals, whether it's fashion or movies or art or whatever. I've represented people of all kinds of industries. You need to take special care. You need to take the time to understand their business, and you need to take the time to understand the person that you're dealing with, because they may or may not react in a predictable way. And you have to be able to take that and be the person in their life they can count on to get a good answer, that they understand, they know, you know who they are.
Oh, wow. Well, that's such great advice. So thank you very much for being here with us today. We really appreciate it.
Thank you.
For more information on this or other topics, subscribe to BloombergLaw.com. You can follow us on Facebook and Twitter. Thank you for joining us. Bye, everybody. Thank you very much.